So Hamilton opens up Federalist number 82 with basically what's a simple reassurance. And that is having both state courts and federal courts doesn't divide justice in the country. It strengthens it. The two systems aren't enemies, they're actually partners that are operating under the same Constitution. And Hamilton wants people to understand that the judicial power of the United States is bigger than just the federal courts. It also includes state courts, especially when they apply federal law. Now, many Americans feared that the new Constitution would wipe out state courts or just simply overshadow them. But Hamilton goes on to answer this rather directly, and it's that state courts keep their authority. They can hear cases involving federal law. And federal courts only step in when the Constitution requires it. The Supreme Court will provide the final unity when needed, and so the judiciary isn't a takeover then. It's a shared system between the states and the federal government. Now, Hamilton's main claim is that state courts retain their jurisdiction unless the Constitution explicitly gives a case exclusively to the federal government. Now, if the Constitution doesn't say otherwise, well, then state courts can hear federal cases. This keeps the system efficient, and it avoids flooding the federal judiciary with just every small dispute that comes up. The federal courts exist to ensure that there is uniform interpretation of national law, not to erase the role of state courts. So, why state courts can hear federal cases then, right? I mean, well, Hamilton's going to emphasize three specific reasons. The state courts are already established, right? They already have structure, they have judges in place, they had procedures, local access, and so it would be wasteful to rebuild everything at the federal level. The second point would be that state courts have always handled national issues. Even under the Articles of Confederation, the states enforced national rules. There was no national judiciary. So all this is a continuation. It's not a revolution. The third point would be Congress can also expand or limit federal jurisdiction. The federal court system is flexible. It isn't trying to replace state courts. Now, the Supreme Court, when it comes down to review, right, why this all matters. Well, state courts can hear federal cases, but the Supreme Court must remain the final interpreter. Well, why? Well, it's because that without a final national decision maker, states might interpret federal law differently. And this, then you could have rights that could vary by just basic geography. And the Constitution would then lose its unity. And Hamilton explains here that the Supreme Court review isn't an attack on state sovereignty, it's a safeguard for national consistency. Federal questions should and must have federal answers. So then we get into exclusive versus concurrent jurisdiction. So Hamilton clarifies a really key distinction. Exclusive jurisdiction belongs only to the federal courts. These are cases involving ambassadors and maritime law, and they can the concurrent jurisdiction can be heard in either state or federal courts. Many federal law cases like disputes involving citizens of different states or something. And Hamilton prefers concurrent jurisdiction because it reduces the workload, it uses existing state institutions, and it keeps justice accessible as well as maintaining efficiency. And so the Constitution reserves exclusivity for situations truly requiring it. And then to take on the argument as to state sovereignty being destroyed, Hamilton writes about anticipating that obvious fear. Does Supreme Court review erase state sovereignty? And he says no. State sovereignty remains strong because state courts keep their own judicial authority, and states control purely local matters. States maintain their laws, their judges, and their legal traditions. And then federal review only applies to federal questions. The Constitution is the supreme law, not the federal courts, and the courts simply interpret that supremacy. So, if we tighten down Hamilton's chain of reasoning, his logic in this one, well, his first one would be that state courts keep their powers unless the Constitution says otherwise. And the second point would be that state courts can hear federal Thirdly, Congress can structure federal jurisdiction flexibly. Fourth point, the Supreme Court unifies interpretation of federal law. And then the fifth point, exclusive jurisdiction is limited and clearly defined. And state sovereignty remains intact for local matters. That's our sixth point. So there's number 82 in 6 easy steps. As far as the tone goes here, Hamilton writes number 82 with, like the mind of an architect. He's trying to reassure a nervous public because he's trying to emphasize things like balance and partnership, this constitutional unity, a practical efficiency, respect for state institutions. He wants Americans to see the judiciary system as a layered system, not just this ladder that results in domination. Our takeaway should be today that 1, state and federal courts share authority over many cases. 2, the Supreme Court ensures one national standard for constitutional and federal questions. And then 3, the design deserves state sovereignty while maintaining constitutional unity. In wrapping this one up, number 82 shows Hamilton's trust in a judicial system that's built on shared responsibility. He believes state courts are essential, federal courts are necessary, and neither works well without the other. And so this essay sets the vision for the dual court system we still use today, which is a balance that keeps justice local but interpretation national. If this one here happened to clarify how federal and state courts fit together, well, hang around because we're running out of Federalist Papers. I'll be throwing out number 83 soon, and this is Hamilton's long and final paper, his long and final essay on trial by jury. Thanks for watching.